Good evening, everyone. A warm welcome to respected Shri H.P. Chaturvedi sir, our speaker Saumitraji Chaturvedi, and all our participants and fellow IPs. As you are aware, IPNet is hosting its 33rd webinar in a series of webinars organized periodically under the umbrella of IPNet, the National Network for Insolvency Professionals. Now, without going further, it's my pleasure to invite Ms. Tina Saraswat Pandey, IP Regional Head of the Central Zone, to deliver the formal welcome address. Tina ji, I request you to please welcome all. Thank you.
Thank you, Pahuja ji. Good evening, everyone. It is my pleasure to welcome you all to today's 33rd webinar on personal guarantors under new insolvency regime and Section 9495 NRP report. We are privileged to have Honorable ex-NCLT member Mr. Harihar Prakash Chaturvedi and Mr. Saumitra Chaturvedi as our esteemed keynote speakers. A special thanks to Sri Ashish Makhija ji, President IPNet, for his visionary leadership in shaping the platform. The membership link is available in the chat and we look forward to having you with us. IPNet has become a vibrant community for the insolvency professionals across India, fostering continuous learning, collaboration, and professional growth. We are committed to supporting IPs through expert-led learning initiatives like webinars, study groups, practical guidance on IVC-related challenges, a dedicated member portal offering comprehensive resources. For those who are already a part of IPNet, thank you for your support. For others, I encourage you to join this dynamic network. Membership details are available in the chat. Thank you for being here. Let's make the session insightful and rewarding. Thank you. I would request Babita ji for IPNet intro video.
Yes.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
I'll now request Babita ji Jain to introduce our chief guest, ex-NCLT member, Sri Harihar Prakashji Chaturvedi. Babita ji,
Yes,
please.
I take privilege to introduce my today's chief guest, ex-NCLT member, Shri Harihar Prasad Chaturvedi. Shri Harihar Prasad Chaturvedi, the member judicial, ex-member of NCLT, judicial member. He did his master's in arts and sociology from APS University, Rewa, Madhya Pradesh. He completed his law degree in the year 1980, as this is also from APS University, Rewa. Soon thereafter, enrolled himself as an advocate of MP State Bar Council and started his practice as an advocate with MP State Bar Council. And he was a lawyer as criminal and civil side in the District Court, Shahdol MP High Court, MP, and at Jabalpur also. He also is junior counsel before the Supreme Court of India in the year 1996, when he joined the legal service, Indian legal service, while practicing as he is selected as international internship in International Lawyer Exchange Program, and he did his internship on poverty laws and class action suit in USA with NAACP, Legal Defense Fund Company, New York. During the year 1983, he joined the Indian legal service on being selected as UPSC and appointed as assistant legal advisor to the Government of India, Ministry of Law and Justice, Department of Legal Affairs, and has been posted at Secretariat, Mumbai. In 1997, he was notified in central government leader in Bombay High Court after joining Indian Legal Services, and while in the services, he also did his LLM degree in Constitutional and Administrative Law and Human Rights Jurisprudence from University of Mumbai in the year 1999. Before joining NCLT as judicial member in the year 2016, he also has been a member law Authority of Advanced Ruling Income Tax Mumbai bench in 2016, and he also served as presiding officer in DRT 1 Chennai branch during the year 2001 to 2006. 2001 to 2000, Honorable Shri H.P. Chaturvedi sir has also been a member of Indian delegation to participate in United Nations Conference Against Corruption held in Panama in the year 2013. He joined as member judicial National Company Law Tribunal, Allahabad, uh, and retired in the year 2021. I think Chaturvedi sir has also he has also been member judicial in Ahmedabad branch also. Presently, he is practicing as advocate in Bombay High Court and in Supreme Court of India.
But I welcome all of you, and I have seen so many my friends who appeared before me in NCLT, Allahabad, Ahmedabad, and as well as in Bombay. And I welcome to this seminar. It is a very important and vibrant issue at this time. So far as the role of the RP is concerned in respect of personal guarantor, I must give a brief introductory and holistic approach about the viewing the provision of EC so far as the personal guarantee is concerned, or role of personal guarantee is concerned. Before the era of the SR judgment, there was a conception that at par with the concept in debt recovery mechanism in DRTs, the liability of the guarantor is coextensive and jointly. But during the hearing of the SR judgment, the government made introduction amending the provisions and given option to the financial creditor, secured creditor, to realize the guarantee from the assets of the personal guarantors. And that conception was modified by way of amendment in the IBC. The challenges was given to that provision, but it was treated to intravirus. Further, the Honorable Supreme Court, in the latest judgment in Lalit Jain versus Union of India and Jeev Rajka case, further upheld the constitutional validity of the provision relating to individual insolvency, personal insolvency, and other provisions. I wish to go in detail, but due to technical glitches, I am not able to tell because I am using my mobile phone for speaking and because there is some network problem. But I must say, and I would like to suggest also, the role of the RP in the case of personal guarantor is concerned, insolvency of the personal guarantor is very much sensitive. Once he is appointed by the adjudicating authority or financial creditor himself suggests his name for the RP, his role to give a submit a report within 10 days and get all inquiry, collect all informations and submit before the adjudicating authority. Here is the role of the RP is made a recommendatory. His report is recommendatory in nature, and it is up to, and it is for the adjudicating authority to consider the report and either to pass insolvency process order so far as individual guarantee is concerned, or to go for individual means bankruptcy. If there is a corporate debtor, then there is a formation of COC and other thing. But if there is individual insolvency, then the matter will go to bankruptcy trust. So these are the distinct lines. Many questions were raised in Jeev Rajka case about the functioning of the RP so far as the personal guarantee is concerned. And the apprehension was raised that there is no provision for natural justice, RD alter partem, and other issues. That full bench of the Honorable Supreme Court, led by then Chief Justice D.Y. Chanchud, while upholding the constitutional validity of these provisions, has said that the role of the RP is only in administrative nature. He reiterated the decision of the Honorable Supreme Court in 631 matters, where say the RP is only administrative power. He is no adjudicatory power. So their question doesn't arise that so far they give a pre-hearing natural justice or what. But he has to collect all information in possible manner from the guarantors, and guarantor is bound to give such information to him. But the Supreme Court also made a cautious about the RP's role, that he should not go into roving inquiry about the status of the guarantor. And he has to give certain, because he is insolvent, there can be some resolution plan for repayment of the loan or something, or he has to go for the bankruptcy. So these are the vital issue where the role of the RP starts. And adjudicating authority has to pass the order in accordance with law as per the sector law. Now the second scenario started when the challenges were made before Honorable NCLT or NCLAT about the debt against the personal guarantor and what is the liability and what is the limitation. And it was always contended that that is time barred because it is claim is not filed or application not moved from the date of default. Or the guarantors play role that our role is start only when the principal borrower fail to pay. Till then, there is no debt exists between the creditors and the guarantors. No liability exists. But Supreme Court, Honorable NCLAT, as well as the NCLT, dealt with this case very carefully insofar as Ahmedabad bench is concerned. One or two matter Allahabad bench has dealt well with it, and Honorable NCLT. And it says that the role of the personal guarantee depend on what is the terms of the guarantee executed between the banks, and if the guarantee is continuing guarantee, then whatever the acknowledgement is given by the principal borrower time to time to bank, it automatically extend a limitation so far guarantor is concerned. Second issue that the amount of the guarantee cannot be recovered till guarantee is invoked. And there will issue, then Honorable NCLT of different ways say that you issue an invocation of guarantee, then you can move for this insolvency of guarantor. However, the judgment was amplified by the NCLT and said if the notice under surface is issued, a demand notice is issued for repayment of loan to a guarantor, or guarantor made inform about the recovery proceeding against the principal borrower, then it amount to the formal notice of invocation of the guarantee, and the guarantor has no escape for that purpose, and the petition against him is maintainable. So that issue was also dealt with properly. Third issue was raised about the jurisdiction of NCLT or DRT. That was also a very crucial issue, because our Act Part 3 of the IBC provides that so far as individual guarantee or personal guarantee is concerned, the adjudicating authority would be the DRT. If there is no insolvency proceeding is pending against the principal borrower corporate debtor. And there was view were taken by the NCLT Calcutta bench and other view. But that issue also was dealt significantly by the Honorable NCLT in various judgment, and say this provision does not debar the NCLT to take insolvency proceedings against the individual guarantee, although there is no pendency of any proceedings of CRP against the principal borrower. That judgment was taken up in the Supreme Court summary rejected SLP. Although law was not clearly laid down, but the view of the NCLT in this respect, that NCLT has the jurisdiction, even individual guarantee, if there is no pending proceeding against the principal borrower, is to be followed. So these are the basic issue which has been settled by the Supreme Court one by one, and law is expanded, law is developing. I want to also add the role of the RP when the guarantor failed to pay the debt and are unable to pay debt. What should be the role? Then definitely it should be the personal guarantor has to go for bankruptcy, and the bankruptcy board shall act as per the Provision Act so far as his rehabilitation and insolvency is kept. There is also provision for the first start procedure. If the loan liability is very simple, then it can be discharged and it can be given. And other issue, it cannot be. So these are the basic line I want to say in this for welcoming remark. And I express my view in very short manner because technical glitches I could not able to read my proper note, but I definitely circulate to you. And I welcome Mr. Somit Chaturvedi. He used to appear before me in NCLT Ahmedabad, and he is senior is very good. Naveen Pawar Saab, so he's a very efficient. He will also play the role in enlightening the issue. And I'm able to hear you, but I'm now not able to communicate through this laptop. So that's all. So I'm expressly apologize for my technical problem. For my technical problem and for Tina madam, so that. So I may allow to conclude, and I'm present in matter for any question and answer.
Thanks a lot, sir. Thank you very much to respected HP Chaturvedi sir for his keynote address. Now I request Shri Ashiji Makhija, IP, General Secretary IPNet, to express gratitude on behalf of IPNet and offer a memento to our chief guest, respected Shri HP Chaturvedi sir.
Thank you, Mr. Pahuja. Well, I think I'm the president, not the general secretary, but anyhow, that doesn't matter.
Yes, sir. Yeah,
On behalf of the IPNet, friends, I take this opportunity to extend our sincere gratitude to Mr. HP Chaturvedi, who is the former member of NCLT, for joining us today as the chief guest in our webinar on a very important topic relating to personal guarantors under the insolvency regime. I think the background or the articulation of the legal nuances which are surrounding the personal guarantors under the IBC, which was articulated by him, provided clarity and direction to all the participants who are present here. I think his experience as a judicial authority also speaks of his continuing commitment to the development of the insolvency ecosystem. So we were very privileged to have him today with us, and his address undoubtedly serves as a guiding light for the insolvency professionals who are dealing with this such very complex matter of personal insolvency. So I think once with a deep appreciation, we thank him, and we also like to present him a small memento, which I can request. Yeah, it is already on the screen. So we will request Mr. Chaturvedi to please accept it online. A physical copy of this will be forwarded to you. Thank you so much.
Thank you very much, sir. Thank you. Now I would request Babita ji Jain to kindly introduce the lead speaker of this webinar, Advocate Soumitra ji Chaturvedi. Babita ji, please. Babita ji, please.
Sorry. Yeah, today's
Babita
our
ji,
lead. Yeah, am I audible now?
Yeah, perfect. Go ahead, please.
Today's our lead speaker is Advocate Soumit Chaturvedi. Mr. Soumit Chaturvedi, practicing as an advocate before Honorable High Court of Gujarat, Honorable Civil Courts at Ahmedabad and Gandhinagar, Honorable NCLT and NCLATs, and Honorable Income Tax Appellate Tribunal, Sales Tax Tribunal since 2015. Mr. Chaturvedi has also appeared before various authorities all over India, vested with adjudicatory and the provisions of various taxation laws. He has also appeared in a few matters before Honorable Supreme Court of India at New Delhi. His area of practice covers constitutional, commercial, insolvency and company taxation, tender service, labor, arbitration, land and revenue information technology, and criminal matters, among others. He is on panel of various PSUs, being ONGC, and has appeared for them in the matter relating to Land Acquisition Act 1894, rights of fair compensation and transition in land acquisition and rehabilitation, acquisition of rights of user of land Act to 1962, Arbitration and Reconciliation Act, labor and service laws, and various tender laws. Mr. Chaturvedi has appeared for various nationalized banks such as Bank of Baroda and Indian Bank as an arguing counsel in matters before the NCLT at Indore, and has also appeared for various resolution professionals appointed by NCLT before Honorable NCLT's Ahmedabad, and Indore. His extensive experience and an advocate in extensive experience and appearance in high courts, NCLT, NCLAT, corporate and commercial laws, capital market, arbitration, taxation, last but not the least, IPR, intellectual property rights, active involvement in insolvency laws has established him as distinguished speaker and a key contributor in the group. I request Mr. Chaturvedi to commence with his the
Thank you for that introduction, ma'am. And I would begin by saying, expressing my deep regards to the Honorable Chief Guest here. And I'm very grateful that he has recognized that we have appeared before your lordships. And I would begin with an anecdote that Justice Chaturvedi actually was the one in front of whom I had appeared in my erstwhile years, in my younger years as advocate, when I was junior to senior advocate, Mr. Naveen Pava. And I still remember Justice Chaturvedi actually acknowledging the arguments of younger advocates and pushing them to argue vehemently in front of in many matters such as oppression and mismanagement matters also. And he was one of those judges who had actually recognized me and asked me what my name actually means. And I still remember him for that very day. And I express my deep regards for the Honorable Chief Guest over here. In pursuance to that, I extend my personal regards to Mr. Kishorji Pahuja, Mr. Ashishji Makhija, Ms. Babita Jain ji, and much particularly Ms. Tina Pandey ji, with whom I've also had or shared a personal working relationship also in the prior. And I would also want to welcome all the members of the community here and all the professionals, those who've taken time to actually listen or attending this conference along with us. So, as Justice Chaturvedi rightly pointed out, I would want to begin with the objective of the IBC, that how actually IBC came into picture, and why was IBC actually required in India at some point in time? Because insolvency laws did exist in many civil law countries, but it never existed in common law countries such as India, having such a huge population, huge corporate structures. Um, so prior to IBC, I would want to say that India had laws such as SICA, RDDB, SURFACI, but somewhere down the line, I always felt that laws such as SICA, RDDB, SURFACI, and even the Companies Act of 1956 and 2013 were vehemently actually were, were, were bent towards much more. I'm so sorry.
Please proceed. Please proceed.
Yeah.
You're muted.
Prior to IBC coming into existence in 2016, laws such as SICA, RDDB, SURFACI, much particularly 56 and 2013 Companies Act also, in my humble understanding, they were inclined more towards the creditors rather than protection of the right of the debtors also. Because ultimately, insolvency laws does not only talk about it never talks actually about recovery measures. We have been scolded by judges time and again that insolvency is not a recovery regime. So somewhere down the line, I also feel that the introduction of the IBC in 2015 and thereafter being notified in 2016 also also takes care of the debtors rather than only the creditors. I've also presented a small PPT for the people out here, and as it is being reflected that why this new insolvency regime basically came into picture and what was the objective behind it. Prior to IBC, there were overlapping insolvency laws in India. There was an insolvency law of 1940, which was not being used at all. There were CPC, there were measures under the CPC which the debtors and the creditors were basically taking, and it was a very slow and an unpredicted kind of a resolution which was coming out of it. and the poor credit discipline, the banks and the other creditors were actually facing a lot of difficulties. So, when in 2016 the Insolvency Act was actually that came into picture, it came with five major objectives. One was to reorganize an insolvency resolution of corporate persons, and the corporate persons also included a definition, or it included the guarantors under the definition of corporate persons, because हमारा topic यहाँ पे basically guarantors से related है. The second objective was the time-bound manner. The third was maximization of value of assets of the corporate debtor. And the third and the fourth was to promote entrepreneurship, followed by priority of payments, जिस पे रेनबो जजमेंट आया, all of us are actually aware of. What are the key insolvency basic features of this new insolvency regime? What actually comes to my mind is the most important objective of this act is the creditor in control model, wherein the COC has been given the power to decide how the debtor is going to be kept as a going concern and how the debtor is going to be resolved. Now, not going into the details of part 1 and part 2 of the IBC, I would straight away jump to part 3 of the IBC, where we are actually concerned with today, which is section 94, 95, and the RP report, which is section 99. Now, part 3 of the IBC was basically designed to provide a structured insolvency framework for individuals and partnership firms, which was distinct from corporate insolvency, offering relief to genuine debtors while enabling creditor recovery. The second was, though it was enacted in 2016, it was only notified in 2019. And that notification was per se then challenged before the Honorable Supreme Court, as Honorable Justice Chaturvedi mentioned about the Lalit Kumar judgment. But I'll want to touch a few points of the Lalit Kumar judgment, which actually would help us understanding the objective of 94, 95, and especially 99 out there. Now, the issue under challenge before in the Lalit Kumar judgment was basically whether a notification in 2019, after 3 years, can introduce provisions applicable to personal guarantors or corporate debtors or not. And that validity of that notification was under challenge. The Honorable Supreme Court very categorically held that there is no illegality in the government bringing into force different provisions of an IBC in a stage-by-stage manner. Because this was a new law. This was a law which was not existing prior to 2016. There were overlapping laws out there. So the Honorable Supreme Court said that government does have the power under the garb of conditional legislation, saying that that the provisions of IBC in a stage-by-stage process, by repeatedly invoking the power of conditional legislation in this regard conferred by IBC, can be brought about. Moreover, the Honorable Supreme Court also stated that there is a sufficient indication in IBC itself indicating that personal guarantors, though forming part of the larger grouping of individuals, are to be in view of their intrinsic connection with the corporate debtors. The Honorable Supreme Court specifically analyzing the facts in this matter, they rightly pointed out that when a company or a corporate debtor goes into insolvency, it is not only the corporate debtor or the company going into insolvency. If the debt is taken from a financial creditor wherein people have stood as guarantors, they also should be there is an intrinsic connection with these guarantors and the corporate debtor itself, and hence in that view of the intrinsic connection, the Honorable Supreme Court felt that even the recovery process of these debtors should be adjudicated by the same adjudicatory process and the adjudicatory forum, which is the NCLT. And hence, the Honorable Supreme Court held that the impugned notification, which was the notification dated 15/11/2019, that was issued within the power granted by the Parliament upon the legislature. The second point, which the Honorable Supreme Court very categorically said, that the introduction or the altering of Section 2, subclause E, F, and G, which brought in the definition or which brought in the personal guarantors under the purview of IBC, provides the necessary statutory backing of the government to apply IBC in such a manner so as to achieve the objective of the amendment, which was to adjudicate insolvency of corporate debtors by the very same forum itself. The second point which I would want to highlight through the Lalit Kumar judgment was just a second. The second point which I want to highlight is the maxim which the Honorable Supreme Court applied in the Lalit Kumar judgment, which was redendo singula singulis, wherein the Supreme Court said that as per Section 60, subclause 2 of the IBC, it alludes to insolvency, resolution, or bankruptcy or liquidation of three categories. That is, one, corporate debtor; second, corporate guarantors; two, corporate debtors; and third, personal guarantors to corporate debtors. And the Honorable Supreme Court very categorically said that this section should apply distributively. That is, the insolvency, resolution, or liquidation process should apply to not only corporate debtors but also to the corporate guarantors. And hence, the part 3 of the insolvency, which applies or which is under discussion over here, the constitutional validity of that part was upheld on this very ground itself, that insolvency, resolution, and bankruptcy process should apply to personal guarantors of the corporate debtors also. This was the basic agenda which was upheld by the Honorable Supreme Court while saying that part 3 should apply or should be taken up into consideration, and part 3 should become a part, and personal guarantors should also come within the purview of the IBC. The next slide which I'll want to go to is directly, I'll want to jump to Section 94 now, because now what is Section 94 specifically saying? Without going into it or without reading, though I have reproduced the entire section, if we can come to the next slide, that what are the key provisions of Section 94? What is Section 94 per se? Section 94, according to me, basically allows a debtor who is a guarantor who has committed a default to apply to the adjudicating authority, which is the NCLT, to initiate its resolution process. Now, 94 subclause 1 very categorically gives power not only to the debtor, but also to the resolution professional on behalf of the debtor to approach the NCLT and file such an application to declare himself as insolvent. The application, however, how the Act very categorically states that these debts or this application should be in relation to the debts of the personal guarantor, which are not classified as excluded debts. The excluded debts are basically defined in Section 79, subclause 15 of Part 3 of the IBC. Which talks about various debts or could be debts in the nature of liabilities which has been imposed in form of penalties by the court. For such debts, the debtor cannot approach the NCLT. Section 94's second key ingredient, which according to me is very important, is that it also included a partner of a partnership firm or the partnership firm entirely who has stood as a guarantor to the loan which has been extended by a financial creditor to the debtor, which is the corporate debtor. And it specifically said that a debtor of a partnership firm can also apply or take advantage of 94. But if the firm is trying to take advantage of 94, then it has to be done by the consent of all the partners. After that, Section 94 also precludes various sections which comes with the ineligibility criteria of a debtor that who cannot apply under 94. And those are specifically enunciated under Section 94, 99 subclause 4, and I'll just come to it. Section 99 subclause 4 that a debtor who is not entitled to make an application are those, one, who is an undischarged bankrupt, secondly, who is undergoing a fresh start process, third, who is undergoing an insolvency resolution process at that very moment itself, and fourth, who is undergoing a bankruptcy process, which is the part 4 of basically of the IBC, which has been notified recently. Now, what is the procedure for filing an application under 94? It's enunciated in the next slide, Tinaji. Now, how an application can be filed or how a debtor can approach under Section 94. Number 1, the eligible debtor who is not excluded by way of 99 subclause 4 can file an application before NCLT providing details of the debt. That details of the debt could be anything. One who has been declared as an NPA by way of a 13-2 notice, a 13-4 notice, against whom proceedings are pending before the DRT. This application has to be filed in the form which has been given, the prescribed form, along with the IBC, and it has to provide not only the details of the debt, but the statement of affairs of that very debtor, which is the guarantor, and the supporting documents thereof. Now, one of the most interesting aspects of Section 94 is the moratorium under Section 96, according to me, because there is a difference between a moratorium under Section 14 and Section 96. What Section 96 specifically says that once a debtor or a personal guarantor approaches the NCLT, the moratorium instantaneously begins from the date of the filing of the application here, application before the NCLT. But what is the difference between 14 and 96? 14 is a moratorium, according to me, with respect to the debtor or the debts of the debtor, but 96 is a very debt intrinsic moratorium. The debt of the guarantor or the amounts of the debts of the guarantor, they are covered under 96 moratorium. So any debt which is owed by me, if I'm a guarantor to a corporate debtor, that cannot be in any manner be, there could not be any action taken by any of the individuals or any authorities with respect to that very debt. And that is what 96 comes out with. The third, once a 94-95 application, in this case, I'm talking about a 94, once a 94 application is actually filed and it is admitted by the Honorable NCLT, herein when the RP actually comes into picture. After the petition under 94 is admitted by the Honorable NCLT, an RP is appointed by the NCLT. What is the role of RP? I'm going to come to it in a few moments. And thereafter, the adjudication has to be done by the RP, has to be done by the NCLT on the basis of the report which is presented by the RP. Similarly, in Section 95, unlike 94, a 95 can be filed against a personal guarantor who is a debtor by a creditor of that very debtor. I have reproduced the section again, but I'll skip on to the next slide, which are the key provisions again. Now, who can file a Section 95 application? A Section 95 application can only be filed by a creditor, either individually, jointly, that is a consortium, or other creditors, or through a resolution professional also, which is appointed by the creditor. What is the scope of the application? The application, according to 95, can be filed against one or more partners of a firm also, other than the debtor himself, if there is a partnership firm, who is a part of it, or against the firm itself in case there is a partnership debt per se. Herein, provisions of Section 69 of the Partnership Act come into picture, whether the partnership firm in itself is a registered firm or not, and so other laws. And it is basically a consolidation of all the proceedings. For example, there are 3 partners in a partnership firm. If there are 3 partnerships in a partnership firm, one is one is based in Bombay, one is based in Ahmedabad, and the other is based in Indore, then all the three applications filed by the very creditor in all the three tribunals can be clubbed, and it can be clubbed and got to or be transferred to one tribunal itself. And that is also one of the most enabling provisions under 95 itself. Now, under 95, if a creditor is basically filing a petition against a debtor, what are the required documentation? The required documentation is one, like the 94 application, there needs to be details of application, details of debt owed on the application date. Second, there should be a proof of non-payment by the creditor, which needs to be given. Third, there needs to be supporting evidence of default or non-repayment. There are some additional requirements also which has been stated. For example, a copy of the application must be served on the debtor. That requirement is not there in 94 because in 94, the debtor himself is filing an application before the Honorable Tribunal to declare himself as insolvent. Whereas in 95, the additional requirement of serving a copy on the debtor is because the creditor himself is filing an application before the NCLT, and thus, as Sir said, the concept of audi alteram partem, ubijus in idem, the principles of natural justice in 95 are of utmost importance, and hence a copy of the application being filed under 95 by a creditor needs to be served upon the debtor. The second is that the application must be filed in the prescribed form, manner, and with an applicable fee. And the third is the documents which are the evidences to establish the debt. Now, once, according to me, once an application under 94 and 95 is filed, an interim moratorium has begun in terms of 96. In terms of 96, just a second. 97 comes into picture. I'm so sorry. Ma'am, you were going to say something.
Please continue, sir.
Yeah. Once a 94-95 application is filed and the interim moratorium has begun from the date of filing, and if it is admitted by the Honorable NCLT, 97 comes into picture. The Honorable NCLT thereafter appoints an RP to prepare a report to be given to NCLT to facilitate the NCLT. The role of the RP under 97 has been defined by the legislature very categorically, and which I have pointed out through a slide for your ease. One is that 97 was introduced to create a structured, impartial, and efficient mechanism for appointing a resolution professional in individual and partnership insolvency cases under Section 94 and 95. Why an RP was required? An RP was required because there needs to be some independence while collating claims or while coming out and while basically objecting and or giving documents to the NCLT to facilitate the NCLT for specifically adjudicating the entire matter, whether the guarantor should be declared as insolvent or not. The role of the RP comes to collation of those very documents. The third was the judicial endorsement, which was given through the Dwarka judgment and the Lalit Kumar judgment, that RP is an officer of the court. He's only a facilitator. He's not an adjudicator, and he has to only present documents to the NCLT under 99 afterwards. We can come to the next slide. What is the role of the resolution professional? The resolution professional plays a pivotal role in the individual resolution process under the IBC. Number one, it is appointed by the adjudicating authority after a Section 95 or a 94 application is filed. The RP has two key responsibilities, according to me. Number one is that they must examine the application as it is and not adjudicate the application. They only have a duty to examine the application and not add words to the application. verify the information provided in the application, and submit a report thereafter to the adjudicating authority under Section 99. Second, the report must include a recommendation that whether the said guarantor or whether the said application against the guarantor should be admitted or rejected under the insolvency application. The RP's duties, they according to me, extend beyond the initial assessment also. They have to collate the debtor's financial information, including the assets, liabilities, and income. They have to evaluate the feasibility of the proposed repayment plan, if there is some. And thirdly, the RP only has to act as supervisor during this repayment period.
Good evening, sir. Good evening, sir. Fine, sir. Fine, sir. Fine, sir.
The difference between 95
Yes,
to
sir.
Continue, Soumitra ji. Babita ji, please mute somebody who is speaking.
Okay, sir.
the difference between 95 to 100 and
Okay, sir.
2 of the insolvency is that in part 2
Okay.
insolvency, in my humble understanding, RP has been given some powers, some adjudicating powers.
Is it Delhi, sir? It's in Delhi, sir? Online.
Mr.
No
Ravindra,
problem, sir.
please mute yourself.
Yeah, that's
Yes, Soumitra ji, continue.
The difference between part 3 and part 2, part 3 talks about 95 to 99 applying upon the personal guarantors, and part 2 basically talks about RP being appointed as the RP of the corporate debtor itself. The basic or the fundamental difference, according to me, is the adjudicatory powers which have been vested upon the RP. In 99, the RP's power are nothing but to collate the documents, prepare a report, and provide the same report to the adjudicating authority, and thereafter the adjudicating authority with a recommendation whether the personal guarantor should be declared as insolvent or not, and thereafter only the adjudicating authority has the power to make orders declaring a guarantor under Section 100 to be declared as insolvent or not. Now, coming to slide number, what are the key features of Section 99 of the IBC? One is the role of the RP. As I said, that the role of RP is purely recommendatory. They do not have any adjudicatory powers, unlike part 2 of the IBC. The RP does not or cannot make any binding or factual determinations. They cannot go ahead and say that, okay, this was done, X was done, Y was done, and hence, according to me, this is what the answer to this very fact is. It is only, their role is only to assist the adjudicating authority in assessing whether to initiate proceedings against this personal guarantor or not. Secondly, RP's role is to examine the application in verbatim as it has been given or as it has been filed before the adjudicating authority. Though RP does have the power to seek further information from the debtor and the creditor, but they cannot go beyond the information which has been given to them either by the adjudicating authority in the application or by the debtor or the creditor. Thirdly, preparation of report under 99.
1 second, Soumitra ji. Let us ask the audience if they have any questions.
Okay.
Before we move to the next, I think there is some question in the chat box also.
It's
That
one
RP
only
shall-
for Chaturvedi sir only. Only one from Chaturvedi sir.
RP shall submit RP's report on repayment plan under Section 106 to the adjudicating authority within 21 days of insolvency commencement date. In case no repayment plan is received within the stipulated 21 days, is RP bound to report non-receipt of repayment plan to adjudicating authority? If so, what should be the prayer?
In that case, according to me, if the RP has not prepared or has not received a repayment plan under 106, then RP being only a facilitator under part 3, he is duty bound to actually report it to NCLT. He cannot sit tight upon it, because if he sits tight upon it, then the duties of the RP, according to me, the duty is conferred upon the RP under part 3 they are very limited. And as Sir also pointed out, that unlike part 2, in part 3, RP is doing more of a administrative job or a facilitator's job or a supervisory job rather than an adjudication job. So the moment RP doesn't receive a repayment plan under 106, according to me, the case would directly go to bankruptcy then under 124 and 125. But as far as the question is concerned, I think so the RP would have to report this to the NCLT that they have not received the repayment plan. So further proceedings under the bankruptcy proceedings, they need to be carried out.
Correct, correct. Anyways, RP is also directed to file periodic reports every
Periodic
30
reports,
days.
which are progress
So-
reports.
So anyways, it is
Yes.
communicated. There is any other question? I think one more question is there. Okay, there is a phrase.
That whether RP has to.
Yes, Mr. Rajender, we are not able to hear you properly. Can you speak
Actually,
louder?
my question is whether RP has to decide the limitation of this application also, whether this is within limitation period or not.
Very important question. Every RP must be having that in mind. Mr. Soumitra, because
Yes.
there are two Chaturvedis here today, so I have to address you
But I
with
would
your first
actually
name.
ask
Soumitra ji,
this is-
there is a question कि we as an RP, are we required to analyze the limitation part also? Whether it is within limitation?
according to me, if I go by the letter and spirit of the law, RP doesn't have any adjudicatory power. RP, with regards to condonation of delay.
No. I'm sorry, you are mistakenly taken. Actually, they want to ask when we report in RP report,
Yes.
limitation point should also be there to tell whether the invocation of the guarantee is within
Because-
limitation.
Yes, it has to be there. It necessarily has to be there because ultimately, the report which is being prepared under 99, all the aspects have to be told to the Honorable NCLT that this debt was, for example, an account was declared NPA in 2015, but however, the application has been made in 2019. There is already a period of 4 years which has passed. So, according to me, RP has to write all the things verbatim which is there, or all the information which it has received or she has received in the RP report, and thereafter the decision has to be taken by the Honorable NCLT under Section 100. But that recommendation and RP's recommendation could be that, okay, the debt is beyond limitation. But ultimately, the call has to be taken by the Honorable NCLT.
Yeah, I got your point. We can summarize it like this: कि RP should specify in RP report कि see sir, these are the facts, and the debt is either within limitation or it
Or
is not in
within
limitation,
limitation.
right? We
Exactly.
as an RP should not declare something, right?
That
We can say कि
according to me, RP shouldn't say that the debt is barred by limitation. The
Yeah.
RP should only say that my recommendation is that it is barred by limitation.
Yes.
The application has been filed after 3 years, which is the limitation period.
Yes. I agree with you that we have to recommend कि on the basis of so and so facts and
ultimately,
the
conclusion
judgments
of the
available.
recommendation would
Yeah.
also depend upon that.
Yeah, again, that is barred by limitation. So I, in the above mentioned scenario, will recommend that it is not, it is beyond limitation. So we should leave it to adjudicating authority after giving our recommendation. Mr. Rajender, is it okay? I think this was the question.
Then that needs to be done according to me. That conclusion needs to be there.
Yes,
Ma'am,
yes.
there are a few more questions.
Yes, sir. There are many
Yeah,
questions.
actually,
Yeah,
I
yeah,
think
yeah.
then this is a one type of not administrative but the adjudicating thing.
This is type of analyzing, recommending, sir, not concluding. Am I correct, Soumitra ji? We just analyze, we recommend, but we don't conclude or form a judgment. Mr. Rajender, you are not audible actually properly. I'm sorry.
There's a
Yeah,
disturbance in his
concluding, but
voice.
one type of
Kindly improve your audibility. We are not
Rajender
able
ji, can
to
you
hear
put in the
you.
chat box? Your voice
Ah.
is very, very.
Okay, no issue.
Yeah,
Yes.
put it in the chat box, please.
What's the
Okay, I will put it
procedure
down.
when the matter was settled before submitting repayment plan? what is the procedure if the matter is settled before submitting repayment plan? Then in periodic report, I think it will go like that also, and a report will be submitted.
Our report needs
Soumitra
to be
ji.
submitted to the Honorable NCLT, and Honorable NCLT thereafter will take a call under Section 100 with regards to it. And again, Honorable NCLT on that also would have to issue notices and hear both the creditor and the debtor whether the actual settlement has taken place or not.
Correct. Whether regulation 22 can be invoked where PG doesn't submit repayment plan. Who is this? Can you please elaborate? We are not able to understand with this two-liner.
Some iPhone user, some iPhone user.
Who has
Yeah,
raised
madam,
this query?
under regulation 22 of the PG process, where the personal guarantee doesn't cooperate with the process, for non-cooperation for the process, we can also report to the adjudicating authority about the non-cooperation. In this case, he doesn't submit the repayment plan. Then can we invoke regulation 22 for non-cooperation of the personal guarantor for the smooth conduct of the process to the adjudicating authority?
Sir, if there is no repayment plan, then according to me, directly a bankruptcy petition needs to be filed before NCLT because there is no repayment plan.
I think your query is answered, sir.
Yes, madam. Yes, madam. Okay.
You see section 121 of the
Sir,
IBC.
sir, can you throw some light on statement of affairs needs to be prepared by resolution professional? If debtor is not cooperating, then what action should be taken in such case?
So if the debtor is not cooperating, I think so because the role of the debtor under Part 3 of the IBC is very limited, according to my understanding. That there needs to be a repayment plan after the petition has been admitted or not. Then, if we go beyond Section 100, uh, uh, the duties of the RP has been given very categorically over there. It says that the RP has to come out with a public notice and call for the claims from the creditors. Thereafter, 103 talks about registering of the claims of the creditors. 104 is about preparation of the list of the creditors. And thereafter comes a repayment plan. So unlike Section 19 in Part 2, if these things, according to my understanding, if these things if there is no repayment plan per se, after all these duties have been complied with under Part 3 of this IBC, then there could be a progress report which can be filed before the NCLT. But in light of no repayment plan, I think so directly the provisions of 121 of the IBC would come into picture. That there is no repayment plan which has come for XYZ reasons.
Correct.
But sir, my view is that if no repayment plan is submitted, then bankruptcy will follow at the option of creditor.
Yes.
Right. So in that case, for bankruptcy, I think statement of affair will play a very important role because it will have all details of bankruptcy state. So how RP will prepare if debtor is not cooperating?
Sir, actually, it is a new law and still it is emerging. If data is not cooperating, we can collect it from the creditors who are already having the statement of affairs or the credit report prepared at the time of lending of loans. Further, there are ITRs. You can approach the IT authority, you can get the passwords, etc., and you can prepare. So from third-party sources, you can do as much as you can do, and you can prepare an estimated statement of affairs. Correct?
Sir,
that is the only option left with us, being a professional.
And ultimately, if it goes into bankruptcy, just to add to what Tina ji says, 125 comes into picture wherein RP becomes basically a bankruptcy trustee over there. And in a bankruptcy trustee, I think so, the IRP would have all the information which it has collated in Part 3 of the IBC. So if there is no further information which is being given, the RP can only approach the NCLT. NCLT can direct the debtor or the creditor to provide the information. But in light of the fact that there is no repayment plan, it goes to bankruptcy directly only on the basis of the information which has been collated up till then.
Correct.
There is nothing else which has been provided as of now under the bankruptcy law also, because RP becomes the trustee of the bankruptcy. So whatever information is there, we have to deal with that only itself.
Great. Soumitra ji, there are many questions. I am reading what are the tasks or role of RP in between the time of submission of report under section 99 and receipt of order from Honorable NCLT, or wait for order?
We have to wait for the order, because once 99 has been complied with and the report has to be filed, the RP cannot take any adjudicatory role or cannot do anything beyond the purview of the law and say कि मैंने report तो file कर दी है, लेकिन I want to go on to some fishing exercise also against the debtor for myself until and unless the court directs so. So according to me, if the provisions of 99 are fulfilled by the RP, then RP shouldn't be doing anything beyond the provisions of 99, because thereafter applications by the debtor could be filed against the RP for misconduct if he or she is going beyond the provisions of 99. And that would open a Pandora's box, according to me. And hence, according to me, in 99, whatever provisions are there, they need to be followed in letter and spirit.
Correct. Anything else? Anyone wants to ask a question, or should we move to the next slide?
Madam,
Yes,
one
yes,
question.
sir. Yes.
Yes, madam. Sir, the matter is settled between the creditor and the personal guarantor, and accordingly, the RP has informed the NCLT about the settlement happened, and that was also recorded in the NCLT order. Meanwhile, during the COC meeting, it was approved that the creditor shall proceed to file an application for withdrawal before the NCLT. Is it okay, sir?
Sorry, sir, I didn't get you. You're talking about part 2 withdrawal of or part 3?
Is under section 100 admission was made. Admission of the application was ordered by the NCLT, the
Yes.
personal guarantor matter.
Yes.
Subsequent to that, the matter was settled between the creditor and the personal guarantor. And
Yes.
during the COC meeting, it was informed that the matter is settled by the creditor, informed by the creditor. And accordingly, the RP has informed the NCLT about the settlement happened. That was also recorded in the order. But the COC also has approved the filing of withdrawal application by the creditor since the matter was settled. Is it okay, or the RP has to adopt any other procedure to get the matter fully out of the court?
Sir, in my understanding, ultimately, if you go through section 111, which is the approval of repayment plan, if the COC ultimately is saying that we have settled with the creditor or settled with the debtor, and there is a 3/4 majority, then I think so the provisions of section 111 come into picture. According to me, that should be that settlement in itself would be approval of the repayment plan, because
Yes.
yes. So thereafter, if 111 comes into picture, then I think so an application could be filed under 114 stating so that after the order which was passed under section 100, the creditor had approached or the creditors or 3/4 of the creditors have settled with the debtor, and an application could be made under 114 to take that settlement as a repayment plan on record.
Okay. Is
Sir,
it proper to file Form D for withdrawal? Form D?
Sir, that I'll have to go into the regulations once. I think so that is also that can be done, but because already part 3 proceedings have been initiated, so an order
Yes.
according to me under 114 also that needs to be invited according to me.
Okay, only one creditor in this matter. That's right. Okay.
So that's a
Sir,
100.
can I ask an adjoining question in this? Section 111 says that 3/4 of the creditors present and voting.
Yes.
Now, let us say there are 3 creditors, one having 35% voting share, other having, let's say, 60%, and the third one having 5% voting share. Now, the 35% voting share creditor was only present.
Yes.
So, can I only consider his vote and take action? That's number one. Now, the second part to it is that that creditor also did not give his, did not vote on that plan, even after the lapse of the voting period. Now, as an RP, can I call for another MOC and put the repayment plan to voting for all the creditors at once and once again?
Fact-centric question, because I think so we have dealt with such a question, I think so, in NCLT Indore, under the provisions of Section 22, wherein an IRP needs to be replaced by a majority of 66%. So I think so what you are saying, the first question, that only a 35% creditor is present, because 111 also talks about, or it also states the word proxy over there. So for example, if there is no proxy also of the other creditors, then 35% could also become the 100% creditor, which is actually standing over there for voting.
Correct. That's true.
Yeah, so if that is the only creditor, then that 35%, according to me, becomes the 100%. But that's a very fact-centric question, and that needs to be adjudicated by the because we cannot call that 35%. According to me, we cannot call that 35% COC member to be the member with the entire 100% or 3/4 of the commercial wisdom of the COC, because COC is already there.
I get your point. My question is pretty much, since there seems a lot of contradiction to what the intent may be and what it says. I mean,
Yes.
my question stands for that. And secondly, now that they have also not voted, can I put for revoting again? And this time include everyone else also.
That is, I think so. You can put a plan upon revoting, or go under, or invite orders under 114. That is up to you. But I think so.
But
If
there are strict timelines, 120 days, and it is very strict in this PG cases.
No,
So
madam, extensions are allowed, because in my case, the
but there should be
NCLT,
a reason for extension, no? If they don't
the
vote
reason
willingly.
the reason given is that the creditors want more time. The creditors have put it on record. So,
Then you
so
have
does
to take
that mean that
approval.
I can put it to the floor for all the other
You
creditors?
should take approval of adjudicating authority and then put for vote for all creditors, because it can't be only for a chunk of only for a specific part of creditors. I think so.
once the
Soumitra ji, you can tell.
once the creditors have missed the bus, Priyanka ji,
Yes.
very deliberately they have missed the bus. Thereafter, the 35% who was the 100% has also missed the bus by not voting upon it. Once days have elapsed, 114 has come into picture. Repayment plan is not there. So if you go by literal interpretation of the law, then you need to invite orders under 114 that there is no repayment plan which has been approved by the COC or by 75% of the COC. But while doing so, if you file an application, the debtor can come to the court and say, no, no, I have a repayment plan. And he can ask or pray to the NCLT to direct the COC members to have a voting and consider that repayment plan. If after that also the COC doesn't consider the repayment plan, I don't think so there is any procedural irregularity. As Tina ji said, it's a strict guideline, and whenever the COC is not taking a decision, I think so NCLT has all the adjudicating powers to say, okay, the COC is not taking decision, that is deemed non-approval of the repayment plan, and hence put the person into bankruptcy. So this is a very fact-centric question which you're asking.
Yes.
And I think so, on a lighter note, I think so you have a matter of such nature which is pending before NCLT somewhere.
Yes, sir. That is another thing that I would like to know in CIRP, sir. Normally, CIRP. Hello, can you hear me, sir?
Yes, I can hear you.
Okay. In CIRP, there are specific provisions for falsification of books of accounts, fraudulent trading, etc., etc. But in a PG case, there is no such explicit provision. In my case, the PG seems to have made given his statement of affairs which do not reconcile with his other information. So what is my recourse? Should I take anything on? I mean, should I do anything?
According to under Part 3, you cannot do anything because there are no provisions with
Okay.
respect to it, because there's no equivalent to Section 65 or a 44 under Part 3 of the IBC.
I am talking about a section maybe 68.
But 68 also
It
does.
is concealment and falsification of books of accounts.
But see, you can always invoke inherent power under Rule
So
11.
should I do that is my question. Or should I, since there is, now there are two ways to look at it. There is no explicit provision, so the RP shouldn't do anything. The other way to look at it is if something has come to my knowledge, am I not duty bound?
Ma'am, can I dodge the question by saying that I would be able to answer it after going through all the papers?
May I assist? May I help?
Please.
Actually,
This is a very important issue that
know,
I
ma'am,
can't
but
figure
see,
out.
madam, we have only 120 days here as compared to CRP, right? There is no section which says we can file such and such application of fraudulent, etc. Further, as Soumitra ji has rightly said, if you want to invoke Rule 11, that will be also a different thing. We as a RP have access to all the third-party resources. We can collect data from IT, we can collect from banks, and we can prepare our own working. Now, what he is submitting, and if it is false, so going into some
I would
other
like,
thing.
Okay.
Madam, I would like to cut this here. You have details of IT. In PG cases, there is nothing that the RP can seek on his own. The RP is seeking information only from the PG or the creditor. I
Madam,
do
they
not have
can't call
anything.
from IT department.
I don't think so. I don't think I have that power.
Okay, I think, can I come in on this?
Yes,
Yes,
sir.
sir.
Okay, see, let's understand, you see, the whole concept. Insofar as CIRP is concerned, typically you have to identify those avoidance transactions. And if there are any statements which are not which is not given the information, naturally you can approach the NCLT for non-cooperation. Now, and the third part, if there are any false statements are made, then of course we have section 68 to 77A, which are typically penalties and offenses where RP does not have any role. In fact, you have to inform the IBBI, and IBBI has created a prosecution cell and they will take action based on the evidence. Now, coming to part 3. Insofar as part 3 is concerned, let us understand the role of an RP in an insolvency case and in a bankruptcy case. In an insolvency case, you are typically a friend, philosopher, and guide of the insolvent. You are not taking over any of the assets. You are not operating the bank accounts. So therefore, you are simply requesting the insolvent to prepare the plan and give it to you. And of course, you will also help him in making it that. Whether information coming or not coming, we'll have to take your own steps. At the end of the day, if nothing comes, no plan will be there, nothing will be approved. Now, in case he is hiding some information, typically, whenever you are submitting any report, you can mention that if you have concrete evidence. And now coming to, as far as avoidance transactions are concerned, again, section 164 and 167 to 167 are there, right? In this thing, but they apply only in bankruptcy, not in insolvency. Let's understand that. Only if you are appointed as a bankruptcy trustee, only then you have got powers under section 164 to 167. Now, coming to false statements under part 3, sections 184 to 187 are clearly there, which are equivalent to 68 to 77A. So they have curtailed into 4 sections rather than having 10 sections in part 2. So this is the whole scenario. But 184 to 187 again are penalty and offenses where RP cannot file any application anywhere. Please understand this. You will have to inform the either MCA or IBBI, and then if they feel that, you see, based on the evidence, they have to take action, then they will take action. So
And I'll go a step further, sir, with your permission.
Yeah.
All these provisions cannot be invoked before 106 at all, or the stage of 106 at all. If a report has been prepared by the RP, as sir actually said, ki RP is a friend, philosopher, guide, and of the insolvent. And I'll go a step further. I think so. And RP is also a facilitator to the adjudicating authority. Ultimately, RP is a link between the insolvent and the adjudicating authority, so that adjudicating authority can pass some order under 100 and admit it. And thereafter, if a repayment plan doesn't come into picture, then thereafter the RP becomes the trustee of the bankruptcy. But very frankly, on a practical note speaking, I think so a lot of water has flown up till then. And I don't think so those provisions wouldn't apply until unless RP has some kind of documents coming from somewhere, some third party authorities, some government authorities, and it's a very long process. But not before, I don't think so, before he is appointed as a trustee or before the repayment plan order is passed.
No, Soumitra, let's also understand one thing.
Yeah.
RP, once the repayment plan does not come, naturally, then the person will be fit eligible to be declared as bankrupt. He is not declared bankrupt automatically. Please understand, there is a difference.
Needs to be filed.
Naturally, if the creditor does not file, it matter ends.
Matter ends, yes.
So therefore, Section 121 is very clear under what circumstances the application can be filed. Or there are only four circumstances, not beyond that. Number one, and so therefore the RP does not automatically becomes a bankruptcy trustee. Somebody else can also be appointed later on. We don't know. So your term is over the moment the plan is not approved. Your job is over. Now it is the job of the creditor or the debtor themselves whether to file it again or not. Otherwise, then the person insolvent becomes a free man. He becomes a normal person. He's not treated as a degraded person like a bankrupt. So in bankruptcy, when we go to bankruptcy, the fraudulent statement like section 164 to 167, like avoidance transaction, then the bankruptcy trustee will have to jump in. In insolvency, he cannot jump in. If you read 164 to 167, the word used is only bankruptcy trustee. That's all. So nobody else is authorized. Like in CIRP in part 2, RP and liquidator both are authorized. But in that case, there is no RP word is there. It is only a bankruptcy. The reason is very simple. Today, as far as a person is insolvent, we are giving him a chance that give us a repayment plan and live your life as a fresh start. आपको करना है करो, नहीं करना है मत करो, आपकी मर्जी है. So if he doesn't do that, then he could be declared as bankrupt. We don't know. He may or may not be declared. And as far as fraudulent statements are concerned, 184 to 187, which applies to entire part 3, whether insolvency or bankruptcy. And it can be invoked at any stage. But all I'm saying is, let's understand, 68 to 77A and 184 to 187, RP does not have power to invoke or approach any court directly. He has to simply provide an evidence either to MCA or to IBBI, and then they will take further action for prosecution if they deem fit. That is all I'm trying to say.
Sir, so am I not supposed to inform NCLT, and do I not become an accomplice if I do not bring NCLT into the
But
picture?
I said, Priyanka ji, whenever you are submitting your report, आपके पास क्या है? आपके पास क्या हथियार है? आपके पास हथियार है report.
112 वाली.
Whenever you are preparing a report, write a paragraph in that. Now, who is
तो
talking?
माने रूल 11 को इन्वोक नहीं करें.
कोई जरूरत नहीं है ना. अगर कोई आपको लग रहा है बहुत मेजर मटेरियल कुछ है, right? See, the point is, if somebody hides and he does not, you see, provides complete information, तो उसका repayment plan ही successful नहीं होगा ना कल को.
तो सर वो तो क्रेडिटर को बताना पड़ेगा ना.
Assuming, मैं वही बात बोल रहा हूँ ना. Assuming you are sure of it. देखिए, you cannot blame the insolvent just like on the basis of a rumor mill कि किसी ने आपको बताया इसके पास ये property है. No, I'm sorry. Let's not get into that. If you have credible information supported by evidence, then naturally, first it is your duty to inform the creditors that look, in the meeting, now I have come across this. He has not disclosed this. He has also got assets, so plan has to be considered in that manner. So पहले सबसे पहले information आप और उसके insolvent के साथ share करेंगे. Give him a chance to come clean. If it doesn't come clean, go to the creditors. If the creditors also don't do that, आपकी जो report जाएगी 106 में, आप उसके अंदर उसको लिख लीजिए paragraph को. Who is stopping you?
अच्छा, thank you so much, sir.
Chalo, great. All right. I'm sorry to barge in. I'm sorry to barge.
No, this was very important. And sir, just a correction. I think 184 में RP inform कर सकता है, and that only particularly relates to resolution and not bankruptcy. To my understanding.
No, 184 to 187, I said these are penalty sections.
हाँ, इसमें ये 184 आरपी इन्वोक कर सकता है टू एनसीएलटी. That's my understanding. I could be wrong.
नहीं एनसीएलटी को नहीं कर सकता ना. दिस लेट अस अंडरस्टैंड. आप देखिए, आप 184 स्टार्ट्स विद व्हाट? पनिशमेंट.
हाँ.
तो डज एनसीएलटी इज अ क्रिमिनल कोर्ट? आपको ये मालूम है, ये जो मैं आपको फिर बता रहा हूँ, 68 to 77 and 184 to 187 are penalty and offences section where a special court has got power, only special court. And special court will take cognizance of these offences only on a complaint filed either by IBBI or by Ministry of Corporate Affairs or an officer authorized by MCA. आरपी को कोई नहीं सुनेगा. और एनसीएलटी की तो बिल्कुल भी पावर नहीं है. बिल्कुल मत लगाना एप्लीकेशन. In early days, let me tell you, in 2017, people were not reading it. Some RP filed an application under section 74, 75 before the NCLT. और NCLT भी को भी पता नहीं था, और NCLT ने भी नोटिस इशू कर दिया. I was present in the court. I said, my lords, you don't have the powers. तो उसको तब समझ में आया, कहना, oh, Mr. Makija, I think we have made a mistake. Then he withdrew that order.
अच्छा, thank you, sir.
File किया. Then reported to IBBI.
Right.
I would also want to learn how can 186 and 187 be used by an RP, sir? Because it begins with a bankruptcy only.
I'll tell you. No, RP नहीं है. देखिए,
only 184 can be exercised by the RP.
Correct. 184 can be exercised, not 186 and
186 or 187.
Naturally. We'll have to read actually the language.
Under 95 to 99, up till the stage of the report, I think so, RP doesn't have to go into all of this at all. जो मेरी simple understanding है. 99, the report only has to include, or the report only has to be made upon the application which has been filed either by the debtor or the creditor, or the information which has been roped in by the creditor. And practically what happens, sir, if the corporate debtor is already under admission, is already in CRP, so I think so ये सारी information तो निकालना is not that difficult also. Some extra.
Samitra, there is a difference. Like in CIRP, the information is only relating to CD. It's also happened in one of my cases. One of the application I was representing the insolvent, and the person filed an application, wrote to the bank, कि इसका एक bank account freeze कर दो. That was in early days. Then I filed a contempt application against that RP. I said, what is this nonsense? How can he block my account? So therefore, those things are there. Anyhow, those were early.
Sir, एक चीज और पूछे to learn. Should the RP go into 184 at all, or should I just sleep peacefully?
नहीं 184 देखिए, मैं आपको बोला कि 184 it is your responsibility. If you don't do that, you may be held guilty under 185. अब 185 पड़ी है.
Yes.
तो सर मैं IBBI को बता दूं, आप बोल रहे हैं?
IBBI को बता दो with credible evidence. In fact, they have created a prosecution cell and they have filed prosecution against in 36 to 37 cases. And one of our case was the first case. When we gave them the information, उस time उनके पास cell भी नहीं था. And then they spoke with me. They said, "Sir, क्या करना है?" मैंने कहा, "साहब, आपकी power है, आप करिए ना, या मंत्रालय करेगा." So ultimately, they created their prosecution cell, and now they have filed 36, 37 applications against number of creditors. So they do take action.
तो सर IBBI को बता देते. Thank you so much, sir.
Sir, 1 minute, sir.
Yes, sir.
Sir, in the bankruptcy, whether we can write suppose we know the name of the bank which they are maintaining the accounts, the bankruptcy was not declared, whether we can write a letter to freeze the account, sir?
Sir, as far as when you are appointed as a bankruptcy trustee, please read regulations. In regulations, there are clear powers which have been delegated to bankruptcy trustee to seek information from any creditor. So you can definitely write and you can seek information. No problem, sir.
Thank you, sir.
Okay.
Trustee is enlarged than more of the IRP. But
Yeah.
sir, I think so 187 ka 185 ka line in itself says that if a debtor or creditor provides information which is false, now who's going to be deciding whether the information is false? According to me, that information is false or not is going to be decided by the adjudicating authority under section 100 after giving or issuing notice to the debtor or the creditor while passing the order, whether that information which has been given is right or wrong.
Actually, I still differ from there, because you see what happened in one of the cases in CIRP. particularly the Delhi bench directed Ministry of Corporate Affairs or IBBI to file a prosecution under these sections 68 to 77A. The matter went to NCLAT. NCLAT actually shot down that order. They said you do not have power to recommend also or direct. I mean, you can simply forward them and say, okay, you should do this. They said you don't have power to direct them. So all I'm saying is they are not authority to declare that, because आपने ही बता दिया कि ये fraudulent information है, तो फिर बेचारा वो कोर्ट क्या करेगा, सिविल क्रिमिनल कोर्ट? तो आपने तो पहले ही गिल्टी कर दिया उसको. Idea is not that. Idea is you have an evidence of false information which you feel, right? You inform the IBBI, let IBBI take a call whether they want to file it or not. And ultimately that court will decide, that criminal court will decide after giving a hearing of natural justice that whether it is a false information or not.
60 sub plus 5 wouldn't
अथॉरिटी ने अगर पहले ही एडजुडिकेट कर दिया तो वो तो बेचारा मर गया पहले से ही. फिर तो उसको पनिशमेंट ही मिलनी है. That is not like
There's some directions could be given to the magistrate to investigate. I am with you on that.
not required. RP can directly approach the IBBI. Not required. Adjudicating authority को तो करना भी नहीं चाहिए. हाँ, they can simply feel. हाँ, कई बार ये होता है कि like things are not there, वो बोलते नहीं IBBI should investigate even the role of RP. वो तो ठीक, so that they can always do. चलो
So, Soumitra ji, shall we move forward to the case laws?
Yes, the case laws are, I think so. The yes, the crowd over here must be aware of the case laws, but these are like as Makhija ji said, and as the others also pointed out, the 4 case laws which I have stated or picked out for 95 to 99 are specifically with regards to this very same thing. That under 99, the legal obligation of the RP is very much limited to the provisions of 99 and not going beyond 99 in any manner whatsoever, wherein they are stepping into the shoes of an adjudicator. The moment they are adjudicating something or directing something through a report, then according to me, that report needs to be quashed down by the adjudicating authority per se. The first case which I have basically come up with is the Dilip Jwarja case of the Honorable Supreme Court, wherein I have pointed out or I would want to point out a few things, wherein the first is that the intelligible differentia which the Honorable Supreme Court drew while saying or while pointing out or differentiating between the scheme of Part 2 and Part 3 of the IBC. The Honorable Supreme Court very categorically said that the adjudicatory function of the adjudicating authority commences under Part 3 of the IBC after the submission of a recommendatory report only, under 99. So up till then, there is no adjudication which is happening. And hence, maybe that's why the intention of the legislature under 96 is imposing moratorium from the date of the filing of the petition itself. But there are a few points, and I think so. The most important point which I want to basically point out is that the Honorable Supreme Court herein very categorically said that the resolution professional under 99 can exercise the powers vested under 1994 for the purpose of examining the application. I think so. Abhi jo conversation chal raha tha, whether they are coming out with any evidence or not. I think so. Supreme Court in paragraph number 75, 77, 78, and 86 of the Supreme Court judgment has very categorically stated that under 1994, 99.4, the RP only has powers to examine the application for insolvency resolution and to seek information on matters relevant to the application in order to facilitate the submission of the report, recommending the acceptance or rejection of the application. And thereafter, the Honorable Supreme Court, in the subsequent paragraphs in this judgment, went on to hold that the process under 100 before the adjudicating authority must be compliant with the principles of natural justice. So, ex parte or natural justice wouldn't come into picture up till 99. 99 के बाद जब 100 में order होना है, when the report is actually submitted, only then the principles of natural justice have to be applied. And hence, while upholding the constitutionality of this third part, specifically 95 to 99, the Honorable Supreme Court specifically went on to say that यहाँ पे हमको जरूरत ही नहीं है natural justice की, because natural justice would actually come into picture only under 100 when the order is being made by the Honorable NCLT. उसके अलावा मैंने दो और जजमेंट्स रखे हैं या पॉइंट आउट करे हैं, because ultimately what I have understood from my limited understanding of 95 to 99 is that 99 uh, if is uh, if is if is interpreted by an RP who is the officer of the court in its letter and spirit, I don't think so the reports can go wrong in law at all. And it's when the misadventure or the adventure begins from the part of the RP under section 99, maybe supporting a creditor or a debtor, I think so therein the problem begins. Otherwise, the Iqbal Jumabhoy case also very categorically said that RP's report has to be prepared as a postman and as a facilitator and nothing else, and they should not go beyond the provisions of section 99 at all. Thank you.
Any questions from anyone?
I think so there are some questions.
There are. One second.
But I think so all of them have been answered.
Yes. So,
Any other questions? किरण एक बार और फिर भी पूछ ले if anybody else, नहीं तो फिर आगे चले.
I would like to ask something. Soumitra ji, when we file report under section 94,
Yes.
on behalf of personal guarantors,
Yeah.
so what RP should keep in mind? Are we validating each and every detail while filing, and or still we are giving a consent and we are independent person?
We are only given a consent, and that's an independent officer out there, because ultimately a form, because it's an application being filed on behalf of the debtor by the RP. The RP is not filing the petition. So I think so the consent is required, and the necessary forms also provide for such kind of a consent. And I think so we have seen in many cases before the NCLT Indore bench also. So this
Yes,
point we discuss.
Yes, because in one of the cases I've seen RP pleading for the personal guarantor. Then the bench has asked the RP that
There
the
cannot
RP is
be any
independent,
I
even
think
though
so.
report is filed through
RP.
RP. Yes.
Otherwise, the entire connotation of Section 99 would go away. He is the one who is filing the application, and thereafter he is the one who is actually preparing the report also.
And what about the Deepak Singhania judgment? Because it is Makhija sir's judgment only. So that we need to understand a little bit from you if you are
So
aware.
I would want
Otherwise, sir is already
from
there.
Mr. Makija only. I
Yes,
would want to speak anything
That is
on.
a landmark judgment which has changed all the bankers' view towards invocation of guarantee. And many of my cases are suffering. So, sir, please.
Okay, see, there are two things which are very important for us. Number one, in fact, we also took a stand because the application was filed by the RP on behalf of the creditor under section 95, because that is also possible. RP can file it. So it was his signature, his affidavit. It was not filed by the bank, but by the RP on behalf of the bank. Now, there we took a stand that, look, one case was, let me divide, because there were two types of cases. One was, of course, Mr. Deepak Singhania, one was for another. For other case, what they did, they started proceeding against the legal heir of a personal guarantor, because by that time, the second personal guarantor had already died. So application was filed in the name of a legal heir. Now, in legal heir cases, I told that we filed a maintainability application that this is not maintainable, but because of Dilip Jwarika judgment, court said, Mr. Makija, we don't want to hear you at this stage. We'll hear you at the stage of 99 application or 100 order. I said, fine, all right. Though, of course, they should have heard me. At the end of the day, RP had filed that application. We filed objections to that application that it is not maintainable. RP in his report agreed with our view that it cannot be filed. Then at the time of the argument, I took that argument. I said, look, this is the application which was filed by the RP. Now he's eating his own words. So what did he examine at the time of filing the application? And I actually came down very heavily at that particular time. So therefore, friends, all I'm trying to say, I think Tina has asked a very important question. that when you are actually filing an application either under 94 or 95, because it is being filed under your signatures, you are filing an affidavit, you have to examine the each and every aspect, factually as well as legally, whether it is time barred or not, or whether it is maintainable or not. I think that is what you required to do. That is one part. Now coming to the other, you see, the order of Deepak Singhania, which was by the in our favor by Allahabad bench, and later on it was challenged in NCLAT, and NCLAT has also dismissed that appeal of SBI. Now we are waiting whether SBI will go to Supreme Court or not, because some days are still left. Now, what was the case? Let us try to understand. In that case, our stand was that the personal guarantee has not yet been invoked. B, and of course the deed of guarantee has not been invoked in terms of deed of guarantee. First, it has not been invoked, and secondly, it is not in terms of because there are certain specific procedure is always provided in a deed of guarantee, that a registered post notice will be sent, and you have to follow that process. Now, the stand which was taken by SBI was, which totally confused everyone, and if all RPs are doing it, that they issued a demand notice under Section 95, which is mandatory. They said when we issue a demand notice, it should be treated as invocation of the bank guarantee, a personal guarantee. Now, my view was, and I argued before the bench that, look, this is not possible. And there are very logical reasonings which we gave, and the NCLAT agreed with our view. Now, what was that particular point which clinched the issue? Number one, I convinced that the default must be committed first before issuing a demand notice. Because if there is no default, you can't issue a demand notice. And how the default will come? When you have invoked the guarantee and have not paid it. So therefore, invocation is a step prior to issuing the
demand notice.
Because demand notice cannot be, because in the demand notice, you have to write the date of default. Now, if you are invoking by virtue of issuing a notice, then to default to hua hi nahi na is stage pe abhi to. Because you are also giving in your demand notice seven days time to make the payment. So if you treat this as invocation, then you can't mention the date of default in the notice itself. So I think the bench NCLAT agreed that, look, it is a prior thing. First, you must invoke, create a default, and then a debtor-creditor relationship is established. Because if you have not invoked it, there is no debtor-creditor relationship. I'm not your debtor. I have given a guarantee. I'm not a debtor. You might have a claim against me, but there is no debt owed by me. So claim will be converted into debt when you invoke, and I refuse to pay. And so therefore, the NCLAT said, issue of demand notice cannot be treated as invocation. So that is what it is required. And there are a lot of judgments of Supreme Court and High Courts also, which says the invocation must also be in accordance with deed of guarantee. So friends, when you are approached by any bank, please make sure that invocation is done prior to sending a demand notice, and two, follow the process mentioned in deed of guarantee. If you don't follow it to the core, your case will fall. It is not simply कि आपने एक email भेज दिया. You have to read in the deed of guarantee what is written. Because in deed of guarantee, typically it is registered post or something, whatever requirements are there. So that is the whole case all about of Deepak.
So, sir, just to come in, sir, मेरा एक judgment reserved है before the Honorable NCLT, wherein a consent decree was passed by the lower court, and
Right.
in the consent decree, there were guarantors, there were the debtors, and there were the guarantors. Now, we have argued the case. I was appearing along with Gaurav Mitra before the Honorable NCLT, and the matter has been reserved. And I think so, therein we have taken this point because the guarantee word has been defined, I think so, in the regulations, is to be a written guarantee which has been invoked. It specifically says a written guarantee which needs to be invoked. What the point which we have taken, because in our case, the guarantee was in the form of a consent decree, which was passed by a lower court. And the invocation of a consent decree in terms of the provisions of the CPC can only happen by way of filing an execution petition before the very same fora or the very same forum. So the Honorable NCLT said to me, you have come directly to this Honorable Court without filing a Section 145 execution petition, and you are saying that I have invoked the guarantee.
No, I think there is a slight difference, Sumitra. I think I'm not really aware of those facts, but let me comment on this. What was the need of a consent decree? That means you have already invoked the guarantee, filed a suit. Only then there will be a consent decree. Na nahi to suit kis baat ka
So
file kiya?
we have been trying to tell the Honorable NCLAT. Now, what the Honorable NCLAT has done, sir, it's an NCLT Ahmedabad matter. I'll not take the names of the clients and everyone. On the basis of the consent decree, first, the company has been admitted under insolvency. The corporate debtor has already gone into insolvency.
Right.
Now, thereafter, we have filed a 94 saying that on the basis of this very consent decree, the person or the company has gone into insolvency. And now, on the basis of with this very consent decree, I'm seeking protection under 94, which was then dismissed by the Honorable NCLT, saying so that this is not invoked yet. So we went.
I'm trying to understand, like when you are saying consent decree.
Yes, sir.
Consent decree comes when you have filed a case somewhere.
Filed a case and there is a settlement which has happened.
Settlement happened between the bank and the company alone, or between the personal guarantor also?
No, the operative part of the consent decree says that the number 1 to 4 are the corporate debtors, and numbers 5 and 6 are the guarantors if they don't pay. If one doesn't pay, then 5 and 6 takes the guarantee to pay it.
So therefore, it is not invoked, na? So consent decree is like a deed of guarantee only now.
No, sir. The thing which I have argued is that the moment the debtor doesn't pay, by way of the consent decree or the operation of the consent decree, because the order has not been overturned.
So they are liable to pay. They are liable to pay.
Guarantor is liable to pay.
Correct.
So there is no invocation required at all.
Therefore, no. Therefore, you will make a demand upon them.
The demand could be through the Section 95 demand notice itself, sir.
No. That can't be there. Now, so the point is, see, they have not committed a default so far. Please understand. If X is not paying, Y is liable to pay. But you have to make a demand to Y, na? Okay, please pay. If he does not pay within 3 days, 4 days, whatever the time is, then he has committed a default.
Also contempt only per se, because the order very categorically says that if you don't pay within 7 days, then you have to pay within 3 days.
I mean, again, as I said,
these are relied on this judgment which you are talking about.
Facts-driven cases are there,
Yeah,
so we'll have to.
these are facts-driven case completely.
Correct.
And Bombay High Court has come out with a judgment saying so that consent decree in itself is an agreement.
No, this is an agreement. I'm not denying, but see, even deed of guarantee is also an agreement, but you have to invoke that, na?
Yes, but sir, as you correctly said, sir, on all the deeds of guarantees, there is a process for invocation.
Correct.
Now, for example, sir, there is a deed of guarantee in terms of a consent decree where there is no process of invocation.
But
Then what?
Did they sign the consent decree?
It's a signed consent decree.
But I mean, they were party in the suit.
The parties, yes, sir.
Okay. Chalo, we'll discuss offline.
So that's why the honorable
Clause for invocation also is non-compliance.
Discussion between the lawyers we should not burden other people here.
Yes.
Okay.
Yes, sir.
So we can conclude. Thank you so much.
Thank
you, Soumitra ji. Thank you, Makhija sir. And thank you, Harrier sir, for the insights that everyone has given. And we have gained a lot of knowledge today. Thank you so much.
I think Ashish sir would like to announce about the next webinar.
I think the next webinar is typically very important. It affects all RPs and IPs particularly, because that is, you see, everyone is wanting what are the improvements which are required. So what we are doing is we are trying to have a panel discussion, like a round table, reimagining the code, a round table on strengthening IBC for the next decade. So I think that is a very important topic. We will request all IPs to please participate. There will be 4 panelists who will give their views for 10 minutes each, and there will be a moderator, and then we will invite the comments and suggestions from everyone. So I think please be ready. If anything is in your mind that, look, the system is not working, it should be changed, and it should be changed for this thing. So I think please come out with those suggestions also. So please join us in the next webinar on 17th of Mr. Ravi.
Thank you, sir. Thank you.
There he will also be one of the panelists.
Okay. Thank you, sir. Thank you, sir. I request Babita ji Jain to kindly offer certificate of appreciation to the lead speaker. Advocate Soumitra Chaturvedi.
Yes, sir.
I think should be there.
Sorry, just a minute, sir.
Yeah, no problem. Take your time.
I think while Babita ji brings it on screen, I think Soumitra, thank you so much for joining us today. We are extremely delighted to have you here and sharing your knowledge and holding the audience for more than an hour. I think that's not an easy job. So we thank you so much for taking valuable.
I learn a lot from you, sirs, today, and from all the audiences out there. And a special thanks to have me, sir, over here. And special thanks to Tina ji, actually.
Chalo, great. We request you to accept it. We'll send it to you in a physical form. So
thank you, sir. Thanks a lot.
Thank you.
Thank you, sir. Thank you, Soumitra ji. Now I request Sanjeev ji Chaudhary to kindly offer a vote of thanks to all of us. Sanjeev ji Chaudhary, sir.
Good evening, everyone. I am representing IPNet Central, and it's a privilege to extend the vote of thanks today. I would like to express my sincere gratitude to IPNet for providing me this opportunity.
The Tina certificate is also there.
So,
moderator.
Yeah.
No problem, madam. After vote of thanks, please.
After the vote of thanks.
First and foremost, I extend my heartfelt thanks to the chief guest, Honorable ex-NCLT member Shri H.P. Chaturvedi sir, and our extreme keynote speaker, Advocate Swami Chaturvedi. Sir, your presence has added immense value to this occasion. Your insightful words and visions have inspired all of us to think bigger and strive for excellence. Thank you for gracing us with your time and wisdom. I would like to thank to our president and our mentor also, to Ashish Makhija sir. Every time, whenever there is some gap, boss appears and fill the gaps and guide us. Thank you, Ashish sir, for your relentless dedication and visionary leadership. Continue to make IPNet a platform of unparalleled importance. Special thanks to Tina madam for as a moderator. Your voice is not there, but you are muted.
Thank you, sir. Thank you so much.
And for time to time anchoring and filling the gap again. And finally, thanks to our attendee members, IPs who have attended today, we have achieved the highest strength of 111. So thanks a lot for all the members present in this webinar. Thank you.
Great.
Thank you, sir.
Thank you, sir. Thank you.